Good morning, good afternoon, and good evening. My name is Paul Daly. I'm the University Research Chair in Administrative Law and Governance at the University of Ottawa, and I'm welcoming you to the first event in this year's Administrative Law and Governance Colloquium, where the theme is executive power. Executive power has been the site of passionate debate in liberal democracies for many centuries. In recent decades, authority has concentrated in the hands of presidents and prime ministers, with voters increasingly looking to these office holders to give effect to their policy preferences. Questions about the scope of authority and accountability of presidents, prime ministers, and other executive officers have therefore become even more pressing. What powers does and should the executive have? Against which standards should those office holders be judged? And who should do the judging? In this year's series, we will examine the role of constitutional text and tradition, other governmental institutions, and civil society in granting and constraining executive authority, setting standards, and holding the executive to account. I'm very pleased to welcome as the speaker to kick off this year's series, Dr. Robert Craig. Robert is currently a lecturer in law at the University of Bristol and has also taught as a guest lecturer at the London School of Economics, King's College London, City University of London, Northeastern University London. His work on executive powers and royal prerogative has been consistently published in leading journals such as the Modern Law Review and Public Law. His publications and expert blog posts have been cited in Supreme Court cases and by Parliament for developing legislation on human rights. And here I pause to note that being cited by the United Kingdom Supreme Court, as Robert has been, is a particular honor because that court is parsimonious by comparison to the apex courts in Canada and Australia in citing academic scholarship. So that really is a mark of quality. Robert has also provided expert commentary to the BBC, CNN, Radio 5 Live, and international television on recent cases and public law. He's presented internationally on the royal prerogative, judicial review, and constitutionalism across the common law world. Robert, it is a pleasure to have you with us. Today, you are going to be talking about your forthcoming book, Royal Law, The Foundations of Royal Prerogative, to be published by Hart Publishing later this year. If I may, I've known Robert a long time, and I've had the pleasure of hearing him speak on numerous occasions. He is an original and provocative thinker who certainly caused me to question some of my conceptions or preconceptions about the nature of authority in the common law tradition. And I'm really looking forward to reading this book, bits of which I've had the pleasure of reading in draft. So Robert, over to you for about, you have a PowerPoint presentation and you'll go through that, and then afterwards there'll be plenty of time for questions and comments.
Thank you, Paul. Can you hear me at this point?
Just loud and clear.
Sure that you... Fantastic. Well, thank you very much for those extremely kind words. It's been a long conversation, well, a great and long conversation that we've had, in short bursts here and there. And I'm hoping that this is another opportunity to bounce some ideas off you and your colleagues and other and students as well, because this is something I've been working on for a very long time. And well, just to start the story off, actually, it was about a year ago. My supervisor, our former supervisor, said, well, are you planning on doing a book tour? I said, I hadn't thought about it, but yeah, why not? And he went, why don't you do a book tour before you publish the book? And then you can take into account the feedback and make it better when you publish it. I was like, it's a very good idea. So I did a tour last year, starting in January. This is the last leg of that tour, really. So over the last year, I did 5 or 6, 7 spots over the spring into early summer. I've done another spot in the autumn and one in Liverpool a couple of weeks ago, and this is the final sort of stop in the journey. So I'm hoping to get this finished off and sent off. It's generated an enormous amount of extra work doing this, obviously, but I'm hoping it's going to make it a better outcome. I'm going to start off by saying, and I normally do this in a room with people in, so I can get people to put their hands up, but I'm not sure we can do that here. I've got two potential front covers, so I'm always interested in people's opinions as to which one they prefer of these two potential front covers. Now, there's a question mark on the left-hand one, which has been deleted and should have been deleted in this copy, but so just disregard that. Is there a way for us to make that clear on the? I don't think there is. Oh, well, I'm going to skip over this fun bit of the presentation in that case, because there isn't really an obvious way to gauge the which side is preferable. Well, maybe you can tell me in the Q&A or the chat later on. Okay, let's move on. So this is the structure of what I want to talk about today, a little bit of background, and then I want to talk about Dicey and Blackstone's definition of royal prerogative. Royal prerogative is, of course, a key power held or retained by effectively the government. And the question is whether or not the two classical definitions can be reconciled. That's what I want to focus on today. So, I should also mention that I want to thank Paul for inviting me to this seminar series. It's a great honour. And I'm looking forward to getting that feedback, especially on the two chapters that I circulated last week. So as part of a larger project, which I hope to submit for publication shortly over the summer, preferably. Right. So it's fair to say that the claims I'm making in this chapter and in this book run counter to the dominant narrative in what I regard as a dominant narrative in public law generally, which I would characterize as a common law narrative. With roots all the way back to Cook and Blackstone. Cook is a particular bête noire of mine. But the first line of the book is English law starts with the Crown. This sets the tone for my discussion, and there's a number of implications that feed through the rest of the book. Related to that first line, the central claim of the book, the core claim of the book, can really be summarized in a single sentence. All non-statutory powers of the Crown are prerogative powers. And there's three sort of implications that you can see on the slide that flow from that, in my view. So the Crown, therefore, has no common law powers. Third source powers, which I hope some of you will have heard of, are mythical. And the Crown has no non-legal powers, which has been claimed by Adam Perry. It has got non-legal powers. I say it doesn't. So I claim that everything done by the Crown is an exercise of royal prerogative. In fact, and I'll come to this in more detail later, I reverse the definition. So I'll come back to it later, but I reverse that definition in terms of the Crown and prerogative, because for various reasons we always focus on the Crown, and we should really focus on the prerogative, but I'll come back to that. So since this project is so focused on the meaning and definition of royal prerogative, it is obviously incumbent on me to engage with the two leading and apparently incompatible versions of or definitions of royal prerogative, which of course is Blackstone and Dicey. Happily, after doing some digging, I think I've been able to fully reconcile Dicey and Blackstone's definitions. The unfortunate corollary of this is that I think William Wade, who had a sort of his own spin or twist on Blackstone's definition, is deeply wrong in his definition. So that you can't reconcile Blackstone and Dicey, in my opinion, without discarding Wade. So that's the sort of first part of the book, really. I further claim in chapters following the two I'm discussing here today that the Crown has no common law powers, which I've already mentioned. I also claim that powers possessed by ordinary citizens that are analogous to prerogative powers, such as contract, should be sharply distinguished from prerogative powers. Furthermore, I claim that third source powers don't exist, and especially as Bruce Harris, who invented the idea, it vacillates between calling them powers and freedoms, which is also tricky. Finally, I claim that the Crown has no non-legal powers, contra Adam Perry. I reframe the case law in the final chapter of the book to account for my attack on third source powers. So that's the sort of framing or the overarching or the arc of the narrative of the book as a whole. Before I turn to the two definitions from Daly and Blackstone specifically that have historically competed as a matter of English, I say common law, but probably first-year public law classes. Let me paint some historical context and narrative and background to illustrate my narrative. And the Supreme Court held in the UK in Miller 1, the Crown was once a plenary legal power before the Glorious Revolution. My preferred image for prerogative power is that of a tree with a common trunk and roots, but with many branches, some of which intertwine. The diffuse yet intertwined nature of the royal prerogative can be usefully illustrated by considering the relationship between the ostensibly distinct prerogatives of administration and justice. In one sense, the prerogative power to administer the kingdom is the fundamental prerogative from which all others are derived. After all, the power to administer his realm is central to the meaning of being lord of the manor. So, the prerogative of justice is just one of the many prerogatives held by the Crown, all of which are legal powers. Prerogatives and were historically deeply interconnected and were originally rooted in the role of the Crown as the feudal lord of the realm. Slide. Good stuff. So this is the definition of the administration prerogative, which I'll let you read rather than reading out. The administration of the country over time came to be delegated to representatives of the monarch who travelled around the country to do so, eventually becoming the circuit judges that we know today. Daly expresses some wonderment at the speed with which the prerogative of justice under the king's judges was promulgated throughout the kingdom. So the administration became the prerogative of justice of it all, was interwoven with justice, replacing the variety of local courts with a law common to the whole realm, hence judicial common law. Thus, I've coined probably my favourite line in the entire book, which is that common law is royal law. Although for reasons I'll explain later if I have time, it will be more accurate to say that common law was royal law. Also notable is that other intertwined prerogatives further illustrate the origins of common law as royal law. This includes the immunity of the Crown from common law, which technically persists to this day, as Emma the Home Office in the UK demonstrated. The prerogative of keeping the King's peace, discussed by Blackstone, is fundamental basis for the whole of criminal law since Henry II, hence the Crown Prosecution Service and the Royal Courts of Justice. The prerogative of suspending and dispensing with the law also shows the origins of common law in prerogative, even if it was put into abeyance by the Bill of Rights, dispensing powers. Not forgetting, of course, that the prerogatives of mercy and pardon are a residue of the royal power to dispense with or suspend the effects of the King's law in criminal cases. I therefore claim that the prerogative is not part of the common law, as is frequently thought. In fact, the reverse is the case. So, I want to give 4 definitions of common law to help preempt some potential critiques. In order to show why the reverse is the case, i.e. that common law is part of prerogative, not the other way around, I need to separate out 4 definitions of common law. There are essentially 4 different meanings of common law, and they should be disaggregated far more carefully than they are in legal discourse, in my view. And here they are. So the first one is, we can dismiss this one very quickly, which is the difference between common law to mean common law systems as opposed to civil law systems. So we can just park that one, because that was obvious when you're using it in that sense. The second meaning of common law is the one I think is the most accurate meaning, and the one that I tend to try to use by default whenever I use the phrase common law. This definition of common law refers solely to decisions of the judges of the Court of King's Bench Division, actually, of the High Court, as amended by appeal to the Court of Appeal or Supreme Court. The third meaning of common law is much broader. Common law is sometimes used to mean all decisions of all courts collectively, including chancery, admiralty, etc., as the set of legal norms or precedents which are taken to be the ratio decidendi of such decision. This definition of common law is probably the one that most people use most of the time. The fourth definition of common law is easy to define, but in my view is problematic at a number of levels. This definition states that common law is defined as all non-statutory law. On this definition, there are in fact only two sources of legal validity, common law and statute. In the sense of a separate a priori third source of plenary judicial power and legal validity, authority or legitimacy, common law in this fourth sense does not actually exist. Historically, common law was royal law, and royal law was prerogative law. And the source of legitimacy, authority, and validity of prerogative law was, of course, the crown. The fourth definition is therefore flawed and should be discarded. The claim that prerogative is part of common law is a banal truism if common law is defined as all non-statutory law. As a matter of definition, however, describing prerogative as part of common law explains nothing. It's just a semantic relabeling, and it is circular. So if common law is wrongly defined as all non-statutory law, then you could argue, if you want to, that all prerogatives are part of non-statutory law. Fine. But since all non-statutory law comprises either prerogatives or common law judicial decisions that were originally rooted in the prerogative of justice, it would be more accurate to describe all non-statutory law by its proper title, which is royal prerogative. It's therefore more accurate to say that common law is or was part of prerogative. In other words, the source of validity of the Court of King's Bench, the Court of Common Pleas, the Courts of Chancery, the Court of Admiralty, all had their origin in the prerogative of justice. There is evidence to this day that supports this narrative of the history of the source and legitimacy and validity of the courts. This case was decided in 2017 in the UK in the matter of X. And here is what the judge said. The well-known and long-established principle that the exercise of prerogative and the inherent jurisdiction, he said, is an exercise of the prerogative, albeit the prerogative vested in the judges rather than in ministers. 5 years ago, 7 years ago. So the methodology of common law is all about remedies. Royal law dispensed by the king's judges focused on remedies. That is why it is commonly said that English law focuses not on rights, but on wrongs. If a wrong was done historically, then a remedy was sought from the king's courts. I was reading an 1800s book the other day, where Professor Hearn, William Hearn, said that the reason why the king could do no wrong is because no remedy could be provided, and therefore, if there couldn't be a remedy provided against the king, there could be no wrong. I thought that was beautiful. The prerogative of justice was the source of validity for the remedies granted by the ancient courts. Those remedies taken together formed a set of norms called common law. But I mean common law in the second or even the first sense of common law, as I explained earlier, which is judicial precedent. It is therefore obvious in my view that common law is part of the prerogative of justice as a matter of history, not the other way around. There are therefore only two sources of legal validity, ultimately in English law, statute and moral prerogative. So in that sense, I agree entirely with Adam Tompkins' characterization of the legal roots of English constitutional law as being bipolar. I should mention that Paul Craig, no relation to me, but he's Professor at Oxford Emeritus, has pointed out to me that custom is something I need to acknowledge. And of course, custom has been absorbed into judicial precedent over the centuries and is basically defunct in modern law, but I must acknowledge that, and I need to do that in the updated monograph as well. Okay. Dicey's definition of royal prerogative. Here we go, I'll let you read it. Dicey's definition of the prerogative as encompassing all non-statutory powers of the crown remains by some distance the most useful and descriptively accurate starting point in analysing royal prerogative, in my view. Although a full definition would also encompass duties and immunities of the crown, Dicey's definition must therefore be adjusted slightly. Dicey's definition is true not only for what might be termed the classical prerogative powers, such as making treaties and declaring war, but also of a large number of prerogative powers that have close analogues with, but are analytically distinct from, judicial common law powers of ordinary citizens. It is mistaken to claim that the crown has judicial common law powers to enter contracts or sue or be sued in the law of tort, because the crown itself does not exercise any contractual powers and is not subject to tort law directly. I discuss this in depth in a later chapter of the monograph. Dicey's definition of prerogative is fundamentally correct in my view. Now, this is a new thing that I've developed, this next slide, in the course of my revisions since my book tour. So this is all brand new stuff, which is I'm very much interested in what people's opinions are of this idea. I want to suggest that there may be useful mileage in drawing an analogy between prerogative and land, recognizing the long-standing roots and connections between the two. This could solve a long-standing problem, which is the fact that prerogative is treated as being exercised by convention of the advice to the monarch. Conventions, however, are non-legal parts of the constitutional system. By contrast, when a prerogative is used in a way that frustrates the intention of Parliament, as we saw in Miller 1, in any act, it can be quashed. This means that, in a sense, it can and must be seen and understood as some kind of legal power being exercised by the government, not just by the monarch. This is potentially difficult to reconcile with the idea that the government simply advises through the auspices of a convention, especially if the court quashes the government decision. If it's not a legal concept, how can a court quash it? We saw that with Miller 2, when the Boris Johnson's prorogation advice was quashed. Odd. How can we explain the apparently protean nature of advice that it's sometimes legal and sometimes not? Well, I suggest an analogy with land. We are used to there being different estates in land, freehold, leasehold, tenancy, etc. I suggest the prerogative should be understood as also having the capacity to have different estates. So the Crown could have the freehold of the vast majority of prerogative powers, but the government has a leasehold of varying lengths, which are legal powers. Okay, so that's my estates in the prerogative, which is all brand new, hot off the press. So I'm very interested in people's opinions on that. So Blackstone's definition is the alternative definition. So Dicey's definition is whatever isn't a statutory power. So Blackstone says this, I'll let you read it. Blackstone suggested that prerogative powers of the Crown are exclusive to the Crown. This is correct in my view. Prerogative powers are indeed exclusive to the Crown, and the Crown only exercises prerogative powers. Other parts of Blackstone's definition of prerogative, such as the suggestion that the monarch enjoys rights in common with his subjects, are flawed, as I will go on to discuss in a moment. His view is predicated on an overtly common law agenda. He can only cite Finch as academic support, and in my view, has actually miscited him. Blackstone's definitional claim that the monarch can share legal powers with subjects rests on an at best mistaken reading of the academic authority. It is therefore inconsistent with how the concept of royal prerogative has been understood, as documented and adjudicated over the centuries. Clarity would be improved if the erroneous elements of Blackstone's definition were ignored. I repeat that his core definition, the prerogative is exclusive to the Crown, is correct. That's how I hope to reconcile Dicey and Blackstone. And I've actually gone further, which is, I think, if we draw a distinction between the Crown and the monarch, the king, in their personal capacity, we could actually say that the Crown has no shared powers at all, but the monarch, especially if you look at Chitty 200 years ago, had various legal privileges in courts as a private person. But if we differentiate those, we can completely reconcile Blackstone and Dicey, because we can separate the monarch's minor engagement, not anymore, with legal rules in courts, and the Crown, which is still to this day, following the Home Office, immune and outside the jurisdiction of the courts, which, by the way, just as that little hair running, demonstrates that the courts, the ordinary courts, are courts of limited jurisdiction, because they don't have jurisdiction over the Crown. And they don't have jurisdiction over Parliament either. So they're courts of limited jurisdiction, which is controversial. So Dicey and Blackstone reconciled. In fact, I think Dicey and Blackstone are both right. Their definitions can be reconciled. It follows from the central claim that all Crown powers are prerogative powers. I disagree with Blackstone to the extent that he claims the Crown has any common law powers. I claim that Blackstone can be reconciled to Dicey by simply pointing out that Blackstone correctly argued that all Crown powers are exclusive to the Crown, not necessarily mean they have no common law powers. It's actually quite challenging to identify an example of a legal power possessed by ordinary citizens that the Crown holds in common with them. At the time Blackstone was writing, of course, it was plain the Crown could not sue or be sued in contract or tort. This was precisely why the petition of right slowly developed to circumvent the immunity of the Crown at judicial common law. It would seem then that the most obvious examples of common law powers, i.e. those derived from contract and tort, could not have been what Blackstone was considering. Where there are analogous powers possessed by ordinary citizens, I claim that those legal powers are facsimiles of prerogative powers and rights, not the other way around, such as legal powers related to property. Legal rights as joint tenants or tenants in common have been conferred on citizens by the courts, which originally derived their authority from the prerogative of justice. The royal common law courts developed rights for ordinary citizens over time and enforced them accordingly, originally under the aegis and auspices of the prerogative of justice. The erroneous aspects of Blackstone's definition have thankfully not diverted the judiciary generally from the more accurate Dacian approach to the definition of royal prerogative. It is to be hoped that the mistaken aspects of Blackstone's definition will be disregarded in future case law, and that a cautious and historically situated approach will prevail in the future. Okay, so moving on, the status of and validity of court decisions today. The claim that the validity of court decisions derived from prerogative of justice originally is, in my opinion, close to apodictic, but it's no longer true. This is because the prerogative courts were abolished by statute via the Judicature Courts Act 1873 to 5. This put the judiciary and the court system onto a statutory footing and put the prerogative of justice into abeyance. This is not to say that common law decisions are in some sense quasi-statutory. Rather, the question that ought to be asked is, what is it that makes a court decision valid? We can ask this question with a local bylaw. Indeed, Hart directly addresses this question in the concept of law. He follows the chain of legality, from bylaw to local council to local authority, act of parliament to sovereignty of parliament. He then correctly points out that it makes no sense to ask what makes sovereignty of parliament itself valid. It would make even less sense to point to a particular statute. Everyone who's taught public law has had a student suggest the Bill of Rights.
Robert has frozen in full flight, which is a spectacular thing to see. I'll just intervene while he's frozen to say that if anyone has any questions, you can pop them in the question and answer box. I think Robert is going to discuss in a little bit more detail the relationship between crown powers in relation to the prerogative of justice and what he calls the contemporary statutory basis of judicial jurisdiction. So these are Robert's slides, which I'm sharing. Just waiting for him to get back. Robert's view here is that most of us would think that the common law courts have inherent general jurisdiction, including the jurisdiction to supervise administrative action, and that this is something which developed organically and incrementally over time. Robert takes the view that this authority, since the Judicature Acts in the late 19th century, and the abolition of the writs, the old common law writs, first in private law in the Judicature Acts, and then subsequently in public law in the 1960s and 1970s, has had the effect of putting that authority on a statutory basis, so that we can't, in Robert's view, really speak of a common law of judicial review and we can't. I see Robert is there, and I'm just making sure that he has the required permissions, and he should be back with us. Robert, are you back?
Fantastic. So, right, so the recording started again. So let me go back to the court order bit, which I think is where we got to then, you're saying. And I'll try and do this a bit more quickly because I want to have time for questions, really. So I'm actually going to skip that. Let me just go to definition of the crown. Could you go to the next slide, please? Let's not tempt fate by trying to share slides again. Definition of the crown. Again, I'm afraid this is the version I sent to Paul this afternoon, but I've had to minimize some of these pictures because I'm trying new gold backgrounds rather than blue, but I'm afraid it's not quite as posh as the version I've got on my screen, which was all pretty. Right, definition of the crown. It follows from my arguments I've made so far that the role of the crown is crucial to understanding the definition, nature, and concept of royal prerogative. The crown is an amorphous and difficult concept, and it's frequently said to have three potential definitions: monarch, government, and state. All three of these definitions are unsatisfactory. It makes no sense to equate the crown with the monarch, as the extensive work by Kantorowicz and others as identifying the king's two bodies has shown. Second, it makes no sense to equate the crown with the government, because the government advises the crown, or as my submission distinguishes leasehold from freehold, on the exercise of prerogative power. Indeed, I would go further and suggest a better way to understand the relationship is to see the crown as the bearer, another way of thinking about it, of the proto-legislative aspect of these powers, conferring a proto-executive element of power onto the government. Although this analogy needs more thought, it might go some way to explaining why the crown remains outside the jurisdiction of the courts, which for reasons I can explore if you wish. Thirdly, makes no sense to equate the crown with the state. The state is a far richer concept than the relatively thin concept of the crown, as it encompasses not just the main institutions of the country, but also potentially devolved assemblies and other organs. It is nonsensical to equate the crown with the state, in my view. This is before even scratching the surface of the relationship between the state and the people. I instead propose a definition of the crown that adopts the same methodology expressed earlier, whereby so-called common law rights are in fact derived from remedies and are parasitic on the remedy. In other words, one reverse engineers rights at common law by starting with the writ system and the remedies secured under such writs, and you work backwards to identify the relevant common law rights. Using that methodology, and on the perhaps bold assumption that my claim is correct that the crown possesses only prerogative powers and no other powers, my attempt at a logical definition of the crown is that it is simply the bearer of the remaining legal powers, immunities, and duties commonly described collectively as royal prerogative. And we have a pretty good idea what they are, because we look at the history books. In other words, one starts with what is understood to be the set of royal prerogative powers and reverse engineers the crown as the bearer of those powers. So in conclusion, I suggest a way to reconcile Daly and Blackstone, which explains why I think all crown powers are prerogative powers, and the definition of the crown as the bearer of remaining prerogative powers. I think common law has been poorly defined for a long time. That needs to be disaggregated, and more care, I suggest, should be taken. And I suggest there are in fact two sources of legal validity in English law: statute and prerogative. So I'm going to stop there, having skipped through the last bit, on the grounds that I'd much prefer to have questions and discussion rather than me continue to chat.
Very good. Well, thank you, Robert, for that that presentation. I'll stop sharing the screen, and people are going to be looking at me, and this is classic sort of radio phone-in show format now. And so there are a couple of questions in the Q&A which I will get to, but I do want to ask you a couple of things before
Yes.
Before we open it. Towards the end there, and it's a point you made, I think more than once. You're talking about the crown and the state, and you talk about the crown being a fairly thin concept. But my understanding of your approach is that everything really flows from the prerogative and flows from the crown as the ultimate source. So how is it that the crown can be a thin concept if it has this preeminence as a source of law?
Good, that's a great question. So I think you're looking at it diachronically. So historically, of course, the crown was the source of all law, including statute, right? And so before the Glorious Revolution and Civil War, it was just one different strand of the crown's and the king's and the monarch's power being expressed through courts or through administrators that became courts or through parliaments, right? So in that sense, it is the source of everything. And back in pre-revolution or pre that kind of period, you could say that the crown was the state. Absolutely, that's somewhat, right? But the big changes have occurred since then. So for a start, Parliament is now the source of authority for things like local authorities. It's the source of authority for the creation of the Welsh Assembly, the Scottish Parliament. It's the source of the authority for the existence of a number of quangos and bodies, none of which can logically or sensibly be described as part of the crown. Absolutely not. But they are definitely part of the state, if the state means the institutions and organs of government that run the country, or the countries within the UK. So once you look at the developments in the constitutional changes that have happened in the last few decades, you can see that the crown is much, much less important. Prerogatives can still be important, mostly foreign affairs, but domestically, the wealth, the statutory basis for almost huge swathes of our life means that the crown diminishes importance. And in my claim is it can only sensibly be defined and connected to royal prerogatives, which means you have to scrape off some of these barnacles like making contracts and these other things that have been attached to it. Now, I will say there are a few statutory powers that have been deliberately conferred on the monarch, like to approve the Prime Minister of Scotland, which was a failsafe to stop someone they didn't like in Westminster, right? That was the argument. But these are individual statutory powers. Parliament can do what it likes. If it wants to attach a statutory power to this entity we call the crown, which I define as the bearer of prerogative powers, if it wants to attach a statutory power to that, it can do that. It's a bit odd, but that's what it wants to do, then we can do it. But to equate the crown to the state now is to, in my view, fail to account for quite a long period of serious changes in the structure of the state. And to that end, I strongly recommend Janet McLean's book, which is on my desk here somewhere. She really does go into this, searching for the state in British legal thought. So she really does disaggregate the attempt to make the crown equate to the state, which I think she does a great job, and I just think it's untenable.
Second question for you.
Yes.
Building on that. One way to understand the common law as a method or as perhaps even an ideology is that it is evolutive. And you've talked about change over time and the importance of changes in constitutional structure and in the constitutional order.
Yeah.
But if those changes are important and if the community, the legal community accepts them as being important changes, to what extent is it compatible with the evolutive nature of the common law to go back to ancient or relatively ancient sources and rebuild the foundations of what the legal community understands to have developed over time? Is there well, you have the question.
I think I have the point you're putting to me, which is an important, really important point, and it's probably the most central point, because I completely accept that there is a strong, if not dominant strand, as I mentioned right at the beginning, of legal thought that believes, for reasons that baffle me, that the common law is in fact the default, and whatever, and my real beef with that strand of thinking is that I'm sort of on board with the common law standing up to the king into the 1600s. I'm kind of with that, I'm definitely with that, right? I'm happy with that. But things are different now. Now they want the common law to stand up to Parliament. Now we have a problem. And we're not only do you have a problem, but the attempt in the 1600s to stand up to the king using common law was thin ice at the best of times. They were trying to draw on Fortescue and this and Bracton, which they twisted and misquoted, in my opinion. It doesn't say what it says, but they're having to do this, and Magna Carta, Cook especially, they're having to make these bricks with the straw because the reality was it all came from the crown, and so they're trying to get around it. So I get all that. So there's this strong strand of standing up to the king and standing up to divine rights and to to power, and I get that from the common law, right? And that's everyone wants to be on that team. Oh yeah, well no, we're not. We want to stand up to power. We want to stand up to the institution. I get all that, right? But now we've got parliament, and so no. Now we've got a problem. Now I don't. Now I'm not happy, right? So you're absolutely right to say there is this strong dominant strand of the common law being the source upon which a huge swathe of constitutional lawyers seem to regard as being the superior law. Hence Lord Carlmoth can say in privacy, there may be situations where the courts will refuse to apply an act of parliament. That is the last word. That's the last word question right there on ouster clauses. Okay. So when the common lawyers go to that point, which is the logical progression of their position, in my view, if you stand up to the king first, now you're standing up to parliament, you're basically saying who's got the last word. And the moment you start saying that to parliament, democratically elected, I have a problem. Now, they've now created in the last 400 years a huge wealth of common law authorities that say the king only has the power. So there's now much more resources there, but it's all built on sand, in my view, all of it. And so you're absolutely right to say nothing. Well, in law, there's no objective facts. If everyone is convinced of something, it becomes true. It becomes what everyone thinks is the legal reality, right? So I perfectly accept that there may be dominant, maybe even overwhelming support for the idea that common law can do various things and stand up to various things. But if I can persuade people that actually this is built on sand and it was actually designed and it was tweaking and messing with things that really didn't say what they said because they were trying to stand up to the king, and I'm shaking him by the hand, go for it. But then you try and do that again to parliament, then we're going to have words. And so my job, I think, is to say, look, thus far, when you're doing it with the king, I'm with you. Try and do that again with parliament, and I'm going to point out that you guys have been making bricks with straw for quite a long time. And if I poke enough at that, I'm going to persuade enough people to go, yeah, why have we got judges making this stuff up potentially and then trying to do it against an elected parliament? And there's lots of people who want them to do it, yeah? And those people are my enemies. So I say enemies, I'm being a bit dramatic. Those people are the people that I am disagreeing with in this perfectly intelligible and rational constitutional dispute. Both sides are in good faith. They're absolutely in good faith. And I'm kind of joking about the enemies thing, but of course there are perfectly reasonable rational views. Democracy is not a monolith. It's not just about parliament. Of course, the court has a role. I'm accepting all of that. Yeah, but still.
Well, I guess to continue the metaphor and very mischievously, I suppose you're going to huff and puff until you blow the structure down.
Well, I put it down, isn't that I just need to persuade people that the narrative that I'm defending is more persuasive and has more is rooted in a more persuasive narrative. But if you want to take it to the really interesting bit, then it's Cavaliers and Roundheads, because if the common law is rooted in the Royal Court of Justice in Royal Courts originally, and then they try and do something and then they will convert it to being a statutory basis, and then they want to do something that's against a statutory basis, they've got to be drawing on some other legal source. There's only one other one, it's prerogative. That means they're a part of the king on the king's team. That means they're the Cavaliers. And I'm on the Roundhead team. Yeah, I'm on Parliament's team, right? And so it could be as simple as the Cavaliers and Roundheads binary that is being played out in this, not postmodern way, but in this sort of ripple effect. So it's like a Rorschach, not a Rorschach, like a Mandelbrot set, where the more you dig, you find the same things every time, like a spirit, Mandelbrot sets are beautiful like that. But anyway, I want to get more questions.
So in terms of Cavaliers and Roundheads,
Yeah.
I think I'm probably more of a Cavalier, if we're being honest about
Excellent, Paul. Let me just note that down.
my colleague, well, you knew this already. My colleague John Mark Keyes has had a couple of questions about the third source doctrine.
Yes.
And so there's case law in Canada, not from the Supreme Court of Canada, as another of my colleagues has pointed out, but there is appellate case law which adopts the third source doctrine.
Right.
And John Mark Keyes asks, I think likes the idea that this can lead to greater judicial control of some types of government action, because judicial review of prerogative powers is generally more restricted, whereas common law powers courts might have a greater role. You may or may not accept that the premise of that question, but then his question is, does your thesis diminish judicial review of what might be characterized as third source powers?
No, well, that's an entire talk, right? So one of my chapters that I presented at a different, I did a chapter each of the institutions I've done, but let me just do the short version. My claim is that third source powers, if you read Bruce Harris carefully, he actually says they're third source freedoms. The government can do anything that's not prohibited by statute or common law, which means the government can do anything. The government can do anything which is not prohibited. That, to me, is a far broader power than my claim, which is that the government must demonstrate that, and I say that they have a prerogative of administration. And the limits of that prerogative are drawn by the courts. Always have been. They've drawn the limits of the prerogative. They're going to draw them more. So I'll give you an example. There's a case I mentioned in the book, Ex parte C, where the court said that making lists of potential offenders, people who are being employed, and they could go off and get the list of people who'd had some kind of mark against their name, and therefore they wouldn't get the job. And there was a list, and Lady Hale said, well, anyone can make lists, therefore the government can make lists. Yeah, so my claim is the prerogative of administration implies to internal work done by the government within its sort of departments. If you start making big policy decisions like we're going to have a central database, or we're going to say people who've been accused of various problems are going to be not getting this job, that's policy. If you want to start making policies, get some legislation or find a prerogative that's not prerogative of administration to me. It's a residual tiny little paperclip ordering situation, right? So that's where the cut is. So if you talk about a freedom to do anything that's not prohibited, my claim is that that's a bigger and larger and less controlled power than the prerogative of administration, which you need to demonstrate where you've been making lists of offenders before, and then explain why this is applicable in the modern situation. You ain't going to do it. So I'm suggesting it's actually more restrictive, my claim, than a generalized freedom to do anything that's not prohibited, which to me is smacks of Locke. It's like second generation Lockean idea that you can do what you kind of like because you have to do for the emergency or necessity. Nonsense. So I actually deny the entire claim that this is somehow more restrictive, this approach. On the contrary, I think taking it as a approach of administration and defining its boundaries is much more restrictive than a general freedom to anything that's not prohibited by the government. I mean, in what universe is it okay for ordinary citizens? Yes, do anything that's not prohibited. Do that for the government? No, there's like multiple mistakes being made there about trying to equate. And this is all Dicey's fault, because he equated public and private. He said that everyone comes to the same court, and government said, no, the French were right. Yeah, okay, that's okay. We can cope with the French being right now and again. They were right to separate administrative law and private law, right? So that's what we've failed to do by equating the government as a private. No, and no. And again, McLean goes through some of these problems, right? So this is all caused by some Dicey and legacy stuff about treating governments and individuals as nonsense. And I'm suggesting that my approach is more restrictive on executive power. But I also just caveat what I was just flag what I was saying before. The underlying presumption, not multiple underlying presumptions. One of the underlying presumptions is, of course, that executives should be stopped from doing stuff, generally, on principle, all the time. There's the common law mentality right there. I mean, I'm not saying the executive should be able to do anything, but it's a bit more nuanced than that. We can say, look, the government got a mandate to do something from an election. Yes. Is the purpose of the judges to stop them doing whatever they want to do? No. Yeah, but that is the sort of underlying mentality of common law. Stop democratic elected politicians doing whatever they want to do. Why?
But Robert, I mean, just to I guess I think this is an important point. I mean, I suppose what you're saying about the list case is that if they want to do it, they have to pass a statute to do
Possibly. Yeah, almost definitely, yeah.
If they can't identify some historical basis
Correct.
for it, which they probably couldn't. So in that sense, I mean, there is a normative basis to your position. The normative basis is that governments can't go interfering with rights and obligations without ultimately statutory authority. And
Right.
why I think this is interesting is common lawyers, and you're right that the common law mentality is the dominant one. That's the dominant ideology here. It is pro-court in the sense that it looks to the courts to preserve people's rights and obligations versus the executive. But what you're saying is that actually, if you think about constitutional structure in the right way, you can also come to normatively justifiable conclusions about the relationship between the citizen, the state, and government.
Yes.
I do want to put to you in that regard a question asked by Michael Dunn. Michael had helpfully suggested earlier on that we just hire you to a job in Canada, and that we would have the pleasure of your presence in persona rather than virtually.
Oh, well,
Um,
yes. Maybe with the
and
Wi-Fi problem. Yeah.
and Michael, well, yes, we had a discussion about that too. Michael asks, if Parliament holds sovereignty, and of which the Crown is a necessary part, and I think you'd accept that, based on royal assent and so on, then
Yeah.
how can it be different for the common law to stand up to the Crown versus standing up to Parliament, which is, at least in some respects, a creature of the Crown? What would you say to that?
Okay. So let me just make sure I've understood that. Is the suggestion that the Parliament is still a creature of the Crown?
What Michael's premise is that the Crown is a necessary part of Parliament. The Crown
Right.
in Parliament being the to give the creature its proper title.
Right. So I think for me, the huge, well, the 30th of January, 1649, is the key date in the entire 1,000 years history of the UK in constitutional terms. That's the day that Charles I was executed. Okay, so the ripple effects of that are still lapping at our constitutional shores, is one of my favourite phrases on this. Yeah, so that's the moment in which it's no longer the Crown working through Parliament. That's a revolutionary moment. Well, the Glorious Revolution, in Civil War, death of Charles I, but the Glorious Revolution transferred the supreme rule. The supreme rule in Hart's concept of law used to be Crown is the highest form of source of law. After the revolution, it's not that anymore. It moved. It's now Crown in Parliament. And the Crown's role in that Parliament is through ministers. And ministers operate as long as they have the confidence of Parliament. They're in fact a committee of Parliament. That is kind of all they are. In some ways, that's sort of technically that's what it is. So I disagree with the claim that Crown's operating through Parliament in that sense. It's not standing up to the Crown anymore if the common law stands up to Crown in Parliament. It's not that situation anymore because of the revolution. It's now standing up to democratically elected representatives. Now, I have no problem standing up to the Crown when it's a hereditary monarch. Sign me up. I'm on the barricades. I'm with you, 100%. If you're going to come in unelected judges are going to stand up to elected parliamentary statutes because it's Crown in Parliament, I'm going to be on the other side of the barricades every time. Why? Because it's the same problem. It's unelected people telling me what to do with my life. No, thank you. That's very kind of you to offer. Get stuffed. Okay, so that's where I have a problem. But it's the same route. The same route is I want democratically accountable power. That's why I'm pro-parliament. So I'm a roundhead, right? Its accountability is everything. So I want to be able to vote so that I can affect the outcomes. I can't do that with judges. I can't vote them out. I can't do that with the king. So I'm on the parliament side for that as well. I can do it with parliament. That's the end for me. That's like a killer end argument point, right? Is that I can throw these people out, or I can agitate and make them join a party or do whatever it takes to try and do it. I can affect the outcome. Can't affect judges. Can't affect the king.
Very good. Michael has a follow-up, and after Michael's follow-up, there are a couple of other questions about the relationship between Crown and Parliament and the historical basis for interpreting or for identifying prerogatives. I'm also going to throw up from time to time I threw up earlier the cover of Janet McLean's book.
Yes, I saw that.
Throw up. There's another recent book by my colleague Marie-France Fortin, forthcoming book on The King Can Do No Wrong.
Oh,
Which
wow. I need to know about
gets,
that.
yes,
Can you
it's a
send me
good
the
one.
proof?
It,
Can I get the
it,
proofs?
it's a good one, and
Oof.
it'll be out
What's the
soon.
surname? Can you spell that? Can you spell that for me?
I'll throw it up on
Yeah,
here.
well, sort me
You'll be
out.
able to see it. So
Thank
I'll do that. But Michael has come back with another question, which I think is on point and is worth is actually going to allow you to get into some of that relationship between the
you.
crown, king, and state, which Fortin does as well. So Michael asks, would it not be better to view it as the operating mind of the crown was transferred to Parliament and fragmented through the ministers? The crown itself is maintained, but the monarch is deposed or deplaced as the locus of power.
Right, so the monarch has no locus of power anymore. It's all gone to Parliament. That's what the revolution did. That's great. Okay, so that's a good thing in my view. Oof. The king can do no wrong. Do you know that phrase? That's a superb title, because the king can do no wrong is probably the single most important concept, I think, in English constitutional history in many ways, because it affects everything else. That's genius. I love it. Right. Okay. So the monarch no longer is a locus of power at all, because all those powers, with tiny exceptions, I'm not going to dwell on them. Basically, there are no real exceptions anymore, in my opinion. All those powers have transferred to ministers in Parliament, basically. All the important ones have for a start. The only one, of course, is appointment of prime minister. When, of course, how can you advise the king on who's going to be when you don't have a prime minister? That's fine. Well, that's a little conceptual issue. But actually, as is clear from some of the literature, it's actually the cabinet that advises. So if the prime minister did resign, the cabinet did. So even that one, the idea that the king is going to make a decision it's just not plausible. So the locus has moved. So now all the power is located in Parliament. That's what the revolution did. So the crown is purely is almost the crown powers are just a set of legal powers that have just been accrued by the government now. If you want to be pragmatic and functionalist about it, right? So the idea that there's some kind of legacy, and I know I'm talking a lot about history, but I'm talking about history and a narrative. There's a narrative arc here. There's a movement of power, and you need to understand where power is now. Yeah, and what I'm suggesting is that where the power is now, it's in Parliament. It has been for a very long time, and the sort of juice is the fact that the judges seem to be testing that a little bit in ouster clauses and privacy international, and that's where the juice is in terms of the last word. I'm not. I think judges are awesome. I'm as a big supporter of judges, and because I don't want them in the political domain. They don't want to be in the political domain. I think we're talking, most of them don't want to be in the political domain either. Almost all of them. So everyone sort of thinks that until we get, Privacy 2 someday, or Rwanda bill, which is going through, right? That's when the rubber meets the road, and that's where we start to see question marks about the location of the supreme rule. I want to maintain the status quo. And I see that challenge as being the main challenge from the judges, not the king.
Very good. And as you say, tumultuous times in the United Kingdom with the Privacy International decision and some of the ouster clauses in relation to the upper tribunal, which is being litigated, and the Rwanda legislation, which is currently going through the legislative process and may, depending on the form it takes, also prompt some what will almost certainly prompt legal challenges. That is going to put into sharp relief the relationship between the judges and the Constitution. Now,
can I just say, by the way, because of the gap, I'm happy to extend beyond Q2 because of the problems. I'm happy to chat indefinitely, but if people have to go, that's fine. But I can push on.
Yes. Thanks, Robert. We were scheduled to stop at a quarter two, but I'm very, very glad that you offered, and I'm certainly going to take you up on the offer. And
I'm happy to chat.
Keep you here past the time. And in any event, all this is recorded, and for the edification of those who weren't able to be here live anyway, it's helpful to have the issues ventilated as thoroughly as possible.
Absolutely.
And in that spirit, My colleague Steve Chaplin, who's an expert on parliamentary law, pushes the line of questioning in a slightly different direction, I think. And he says, you know, we've been talking about the relationship of crown and common law,
Yes.
but there's also constitutional convention, and much of the relationship to crown and parliament is regulated by convention in relation to royal assent, in relation to formation of government, the Crown acting there on the advice and consent of the two houses. Where does convention fit into your framework, Robert?
So absolutely, I agree that convention governs most of the practical exercise and usage of royal property power. Absolutely. So royal assent is granted on the advice of government. And last time it was refused in 17, everyone knows this, 1707 Queen Anne, blah, blah, blah. Everyone knows this, yeah? So there was an interesting example during the Brexit process where the government was forced out of the controlling of Parliament, couldn't control the House of Commons anymore, and they passed a Den-Burt bill and the Cooper-Letwin bill against the will of the government, which never happens normally because they control the business. And there was a suggestion made that the royal assent could be refused on the advice of the government, because that's what happened in 1707 when Queen Anne's Scottish militia bill was done on the advice of the government, and legal powers don't fall into destitutude, whatever it is. So totally accept the convention deals or is a crucially important part of constitutional public law, quote unquote, even though it's technically not legally applicable or binding. And it's an important part of the understanding the Constitution. But as I think I said it earlier on, I think there's a bit of a sloppy thinking about some of the idea of convention with some of the exercise of prerogative powers being just advice that then the monarch makes a legal decision. My claim is that, as I said earlier, if someone uses or advises or Prime Minister advises the exercise of a prerogative that clashes, like foreign affairs or treaties, with a statute, then suddenly it becomes somehow a legal question, which is then quashed. So I question whether or not that's really an exercise of convention, or that I think convention may have gone too far. And it's so to answer your question directly, I think convention may need to be constrained a bit in its relevance to some of these questions, because I think these are legal questions going on. And it's just as much a legal question exercise of treaty power when it conflicts with the statute. If that's a legal question, then it must be an exercise of treaty, legal exercise by the government, is my claim. If it's not got a statutory thing, because the only difference is there's a statute that overlaps. That's not an important factor. So it must be a legal thing, which means that it's not about convention. I think the exercise of the legal, or the advice itself must have a legal basis. And if the exercise has a legal basis, we're outside the realm of convention, because conventions are not enforced or quashed or dealt with by courts. So I suggest that convention is still very important, but I think it was less important in this context than if my arguments are accepted that the government's exercising a legal power of some kind, then the conventions become less crucial.
Putting up the
Oh,
the covers of your forthcoming book again. Remember, folks, the question mark is gone in the option on the left. Now, Martha McDougall asks, and this is a question which is historic, I guess, and goes maybe to methodology in terms of identifying powers that might exist. She says, it was mentioned that a declaration of war was a prerogative of the crown.
yes.
The command of the armed forces belongs to the monarch, but Parliament,
Yes.
under the Bill of Rights, must consent to deployment of armed forces. And then asks, what role does prerogative play in the defense of the realm? Any thoughts on that? A lot going on in that question, I appreciate, but
so I haven't read the Bill of Rights recently, but I thought the Bill of Rights required the funding of the military to be approved
Well, I think we could probably argue the toss on what exactly is required as between
Yes.
Parliament and the executive in terms of consent to military
Yeah,
action,
I
and
think
the
I'm also right in
conventions there
saying
are emergent and shifting.
right.
But I suppose the question is the question is in that area. To what extent does the prerogative of defense of the realm override those conventions or otherwise justify use of force, perhaps and perhaps domestically, or do we live in a world where it is all about statute now?
Okay, so there's used quite a lot. Let me unpack that. Number one, um, use of force in terms of declaring war is abroad. So that's not an available power domestically.
Yes, sorry. I actually I was my fault. I because this proposition was actually put at an event I attended over the weekend. In a situation of national emergency, is there any sort of prerogative which would allow the government to mobilize the armed forces or some other executive entity to exercise authority which would supersede existing authorities. But this is a very peculiarly Canadian question, though, because there is a federalism dimension to it, as between what the provinces do and what the federal government could do. So
well,
perhaps,
yeah, I'm not going to look at that last point, but I will say that in the UK, the deployment of the military in support of the civil authorities in times of emergency is now statutory. As far as I think that's, I'm pretty sure that's right. But more importantly, I wanted to make this point, which is the Civil Contingencies Act 2004 is the emergency powers basis for the British government now. And I think that's put any prerogative residual Lockean sort of break the law to do what you like situation into abeyance. That's my view, to such an extent that when the COVID situation happened, I didn't think there was any prerogative left at all under any circumstances. As it happened, they didn't use the Civil Contingencies Act. They used a more base a Public Health Act, which was they didn't even get to the CCA. They went before they even got that, and they used that to lock people down. So I've just published an article in the European Human Rights Law Review saying that was completely ultra vires, right? So and so I had a complete I'm very much against all of the lockdowns, etc. And I based that and I didn't even occur to me to do a blog even to say, well, what happens if you can't use the CCA because you can't convene Parliament to do the 7-day check that you have to normally do? What would you do then? So there is, since I've written that, I've thought and wondered whether or not there might be some kind of Lockean thing that if Parliament cannot sit, whereas the CCA requires a 7-day approval, but it can't happen now because we can do it online after the Zoom. But there was a little gap, there was a little window there. Is there circumstances where the statutory powers can't be exercised because they can't work? Could that be a residual prerogative power? And the answer is possibly, but I can't see how now when you've got Zoom. I don't see how. So, but there's a very interesting sort of very, very residual emergency situation thing going on, which could be relevant to this question about armed forces and defense of the realm and use of these forces domestically, which I think was the question that I was asked. And linked to that is, does prerogative defense of the realm still have a role? Absolutely, it does in the UK. It's still the Navy. I think the Navy technically still has the power to press men. It's one of the prerogatives in Chitty. We all know about this. And it hasn't been overruled. It hasn't been abolished as far as I know. So theoretically, you can still press gang people go and serve in the Navy, I think, right? So, but it's one of those ones that's just inconceivable. It doesn't work like that now. So, right, I mean, I was going to go.
Well, let's hope so.
But let's leave that.
Let's hope so. I was smiling during your response to that question because my professor of constitutional law at University College Cork and someone I've known for a long time and worked with as well, Professor David Morgan. The prerogative, for complicated reasons, didn't survive Irish independence. But
Correct,
Professor
yeah.
Morgan always he pointed to exactly that possibility, that there would be an outbreak of contagious disease. He wouldn't be able to convene the legislature to debate. And Steve Chaplin points out in the Q&A that you could have, you might have this arising during a period of dissolution when there's no parliament, and that might
Yeah,
complicate things as well.
sure.
Two other questions for you before you go. Two kind of radically different ones. One is about the prerogative of a state, and I think I'm gonna
Oh, brilliant.
gonna leave you. We'll talk about that last, and I might have
Okay.
some follow-up questions on that. But I just want to close the loop on what we've been discussing about, because John Mark Keyes has come back with another pertinent question and asks if the Prime Minister has replaced the King as the locus of power in the Constitution, and if that is the case, whether the House of Commons, and I suppose in there's a challenge to your one of the propositions, one of your premises, which is
Yeah,
that you want to be able to vote the bums out,
right.
which I suppose you can, but if Parliament, House of Commons in particular, is being controlled by the Prime Minister and the Prime Minister's office, where does that leave us in terms of the legitimacy of prerogative and various forms of oversight?
I love that question. It's a great question. Thank you very much. It allows me to talk about another chapter I've just written in the book, just briefly, which is that I don't think that we vote for just MPs anymore in Westminster systems. In Westminster systems, I claim that our votes are now bifurcated. We vote for the party and the manifesto, and we vote for the local MP. And we do it both at the same time in a fused system. And therefore, there's a sense in which when the constitutional laws got to reflect political reality, and when a government says they're going to go to the country, that's not a meaningless statement. Whereas if you believe you only elect your local MP, it becomes a meaningless statement. Because how does the government go to the country? We can't. Actually, in the modern world, we vote for the government and parliament in a messy way, but democracy is messy. Yeah, and we vote for both. Therefore, they have a direct elective mandate in the government and in parliament. And one of the problems I have such a problem with the referendum is that it bifurcated those two elements, which normally fuse together, because having a majority in parliament means you can drive your agenda from your manifesto and the slate of executive that's been elected. It's not just your local MPs. So this is an argument I'm putting forward, and I've published on this, and that explains why, in my view, the idea that the executive is some kind of unelected dictator, or Helsham's elected dictatorship nonsense, doesn't account for the fact that A, you're actually electing the government and the legislature at the same time. B, they have to work through those MPs to get what they've done. And people think that somehow there's a monolithic party control, but actually what that means is that within the party, there's all these factions. And you've got to convince enough of those factions within the party to get a proposal through. And all this action happens way before the votes in parliament, which everyone thinks is where it's happening. No, no, no. The real action happens before, within the party, as to whether or not something's going to get through. So actually the accountability levels are high, but within the party. And there are multiple factors. So all of this goes to the point that, in my view, that the idea that somehow with this, the checking the executive or checking the House of Commons requires judicial involvement, which is, I think, implicit in that, and that because they've got such control upon them, they can go off and do what they like. No, 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 that's not how the system works. It's very, very difficult to get anything done. And if you get things, legislated through, well done, yeah. And what are the courts doing? Going, oh no, we're going to tell them, no. Okay, so that's my reply to that one. It's a great question, but it goes. My answer is that our vote is now bifurcated, which is not the orthodox position.
My only editorial comment there, and I find that largely persuasive, I should say. My only editorial comment is that in theory there's accountability within the party, but
Sure.
the fact that leaders are elected by party members is something which introduces an important dynamic, I would say, and the mechanisms for removing a leader are have to be closely scrutinized, because I do think there is a tendency when a leader can rely on the support of the membership at large rather than the support of the members of parliament in their caucus. It creates a different locus of accountability and tends to centralize power in the party in the hands of the person who happens to be the leader at any particular time, because they have this broader mandate. But we can argue a toss about
Well,
that.
I just wanted to say that I've just literally had a 3,000 word piece accepted for a piece with Richard Johnson, who works at QM through Policy Exchange, is doing a whole chunk on this sort of area. And my contribution is the case against the selection of party leaders by anyone other than MPs. So
Good for you.
100% with you, and I'm about to be published saying that. I think it's a disgrace that the local parties, the parties elect the leaders, because MPs choosing them have got the mandate of millions of people, whether they vote or against, they've got a mandate. Whereas national party voting through the people membership is a few 100,000. Ludicrous.
Well, I think on that we might agree. Now, last question, and we'll finish on this theme. You mentioned the prerogative as a state's conceptualization. You also mentioned that it was something you developed in the course of presenting your work over the past year. The question is, I'd be interested to hear more. And what are the strengths, weaknesses, and opportunities of this model? And you have some slides on this which I can go to if you want. But why don't you tell us about the well, you have you have a slide with a heading and a picture, which is very nice. It's a nice backdrop. Tell us then about
on the estates in prerogative, or the definition of the crown.
So it states in prerogative in
okay. Okay. So I think that the crown, the more I think about it, we know that the king, the monarch historically, is the capite, the top legal owner of all the land. The allodial title is with the crown, right? With the king, historically. Okay, so that's your starting point. Now, I think, and there's loads of strengths and weaknesses, and I've already mentioned what this means, but I'll just recap really quickly. I think the crown owns the quote unquote, or it's an analogy, it's not an actual legal claim. The analogy is the crown has the freehold of almost all prerogatives, not including, for example, appointing the prime minister. That's still held by the king, not the crown, because the king, in theory, might have to exercise some actual discretion. So that's like being a freeholder, but with rights of reversion. Okay, so if you want to use the analogy, push the analogy too far, I'm not a property lawyer. So that's the freehold. And my claim is that the government has a legal power in its advice, in its decision-making power, when it's so-called advising the monarch or the crown in the exercise of the freehold, right? And I'm suggesting that should be analogized with leasehold. So that's the argument. Now, strengths, weaknesses. I'm pushing against a big consensus, as I think one of your questioners said, that it's all about convention. But it's a question that's raised by Mark Elliott. He says there's a tension here between the idea that when executive advise on something, there's this vagueness about what its legal basis is. No one really asked, no one's really dug into what the basis of this advice is. And I suggest that it's got to be legal in some way. Now, you can either pitch it as part of the administration prerogative, is that the executive, as part of the administration prerogative, advises the king. So that's like an administrative function. But then again, that would also have to be something that's been conferred on the executive by the crown in some way. Something is conferred on the executive that allows them to make these decisions, in my view. And it's got to have a legal basis. Otherwise, how can the courts look at it? So the strength is it addresses a small, but if you look at it closely, real problem. So that's the strength. The weakness, it's not really, I'm not clear in my mind what is the nature of that legal basis for making that recommendation or whatever it is that's going on. Are they actually exercising some executive version of the power? Don't think so. Does that mean, yeah, this is tricky. Look at Miller 2. Look at Miller 2, right? So the government advised the monarch to sign the prorogation, to sign a prorogation order. That prorogation order was given to the Lords Commissioners, who went into the House of Lords and read it out, which Lady Hale said was a blank piece of paper. Then the royal assent for one of the bills that was read out at the same ceremony was reissued, just in case it was invalidated by this. This is a chain of legal events. But apparently the first item in that chain of legal events isn't legal. But that was the one that was quashed. How do we deal with that? The weakness is, what is that relationship? I don't know. What is that relationship between the government's legal basis for telling the Queen what to sign the prorogation? What is that relationship? Because it's not strictly, it's not as if, I don't want to use the property, I don't want to press the property analogy too far. Is it a notification of leasehold termination? No, it's not. It all becomes, there's a load of baggage immediately kicks in, you see, if you start going too far down the land or property angle. So the weakness is, that's not clear. That's the weakness. The opportunity is give some clarity to the courts so they can go, we're quashing a legal decision, a legal thing, when we say that the government has given advice that's outside its powers. The quashing, it's a legal quashing. That's an opportunity. The threat is, well, I don't know if there's a threat. SWAT, that's the broad elements, isn't it? The threat, I don't know if there's a threat. I don't know. I don't have any, off the top of my head, any answer to the threat bit.
All right. Well, thanks for that, Robert. There's one last question. People are.
I'm happy to chat about this stuff.
Well, we do.
Already.
I'll have to go eventually.
No
John Marquis is back again with another question. He says the basis of government advice to the monarch is convention, and he's asking you to clarify whether you're proposing to transform that into a legal basis. So should the
Yeah, that's exactly my proposal.
Right.
That is exactly what I'm saying. Because if the advice is on treaty making powers, to go back to the classic distinction, the case called Rees-Mogg, who's current Rees-Mogg, he's an MP in the UK. You might not have heard of him, but he's on the right wing of the Conservative.
It was his father, the editor of the
editor of the Times, and he brought an action saying that one of the European treaties was in some way unlawful, and that the signing of it by the treaty was ultra vires, and the court didn't kick him out on standing because, quote, he has a long-standing interest in constitutional affairs, which apparently gave him standing. Everyone laughed hilariously, just because they didn't want to dispute him on a technicality. And the court said this is high policy. This is pre-Miller 2, right? So this is high policy stuff that we are not qualified. There's no legal, test that we can apply. So it's high policy legal stuff. So we're going to reject it on the grounds that we don't have the justiciability. It's not justiciable, right? But in Miller 1, it's exactly the same power, treaty-making power, being used to trigger the exit under Article 50 from the European Union by the United Kingdom. It's the same one, it's treaty property. And they quashed it. How can you quash it if it's not A, justiciable, but B, not a legal power, if it's just advice to the monarch to do it, right? So I think we need to extend the legal bit of these questions so that there's a consistency between the government's decision that was quashed in Miller 1. It wasn't the monarch's decision, it was the government's decision. And it was quashed as a matter of law. Therefore, in some sense, got to have legal basis. Even if it's ultra vires, let's not get theological about it. Yeah, that's a legal question. Whereas in Rees-Mogg, it was treated as high policy and therefore outside the legal jurisdiction. It's not a legal question. It's a matter of policy and convention and yada yada. That there's a tension there when it's the same flipping power. I think there's a tension there, and I'm suggesting that labeling it as a type or as an offshoot in some sense of the treaty prerogative, not just the monarch's exercise of that prerogative power, but also the government has in some sense had conferred on it an aspect of that prerogative power qua law, there's a more accurate descriptive account of the legal issues at stake than has been hitherto identified, where it's all a bit woolly and no one's really addressed it and dug into it. And I'm trying to give it some oomph.
And that is, I think, as good a place as any to stop, because I do think the contribution of this work is indeed to put back in question many preconceptions we have and attempts to bring some analytical sharpness to various issues that have been left vague or undecided over the centuries, and even today, as you say, sometimes you read cases and you see constitutional controversies, and we're running away headlong from facing up to some of the inconsistencies and challenges that we see there. So, Robert, thank you very much for talking about your forthcoming book, Royal Law: Prerogative Foundations, out later this year with Heart, we hope. An interesting and provocative take on the foundations of our constitutional order in the common law tradition. Thanks for sticking with us as well through the technological difficulties, and thanks for
My
being
apologies.
such a good sport.
Yeah, that's one of those things.
It was a pleasure to have you. So thanks very much, Robert. We'll be back for the next installation in this series at the end of February with Professor Peter Shane. Might have an intervening discussion about the litigation about President Trump in the United States and Article 3 of the 14th Amendment to the Constitution and whether he can actually serve as president. But I'll give you news of that in due course. So thank you, everybody, and have an excellent rest of the day or evening, as the case may be. Thank you.
Thank you very much, Paul. I really enjoyed that today. Very useful. Thank you.